Hi everyone, I'm going to be presenting the Holland case with you, which comes to us from the Sacramento City School District versus Holland in the Ninth Circuit in 1994, and it deals with the issue of least restrictive environment or inclusion. Our student profile here is Rachel Holland. She was a 9-year-old in second grade at the time. She was diagnosed with moderate mental retardation. She had an IQ of 44, which is equivalent to that of a 4-year-old. She was well behaved and popular with peers, and she reportedly enjoys school and is motivated to learn. Background of the case: from 1985 to 1989, Rachel received special education services from the Sacramento Unified School District. From 87 to 89, she spent no more than an hour a day in the regular classroom, so the vast amount of her time was in a special education setting. Her parents asked for full-time inclusion in regular class. The district denied their request and instead offered partial inclusion plan for non-academic classes only, so things like PE, recess, art, music. This also required Rachel to make 6 transitions a day, so she went between the special ed room and the gen ed room 6 times a day. The parents moved Rachel then to the private Shalom school, where she attended kindergarten through 2nd grade. While at the school, she was assisted by a part-time aide in the general education classroom. Her parents appealed the district's decision for partial inclusion to a state hearing officer. The district claimed she was too handicapped to be placed in the gen ed classroom full-time. The parents argued that Rachel learns best socially and academically in the gen ed classroom. And the hearing officer initially sided with the Hollands, and the district then appealed the decision to district court. The issue of the case here is, should Rachel be placed in a general education classroom or in a special education room? So it deals with the topic of least restrictive environment, and what portion of her time should be spent in each setting, which is appropriate. So again, dealing with inclusion or mainstreaming. A plaintiff would be the Sacramento Unified School District. They're the ones appealing the case. They argued, again, Rachel is too severely handicapped to be placed in the regular setting. She would not benefit academically or socially from that placement. They also stated that the cost of supports for regular setting would be too great, and they estimated those at $109,000. The defendant there was Rachel Holland, and Rachel again claimed, and her family claimed, that she learned best socially and academically in the regular setting. This case connects to the law primarily through least restrictive environment. Students must be provided a free and appropriate education at public expense, under public supervision and direction without charge. So the question there is, was her education appropriate, or should she have been placed in a different setting? Children with disabilities are to be educated with non-disabled children to the maximum extent appropriate. And again, that connects to that least restrictive environment, inclusion, and mainstreaming that are identified or implied in IDEA. The court used 4 factors to really determine who won this case and what the appropriate, keyword there, what the appropriate setting was for Rachel. They looked at academics first. Did she benefit from a regular classroom setting compared to a special education classroom, or were her needs at least satisfactorily met in the regular education classroom? The second point were the non-academic benefits, a lot of social interaction. So did she learn from her peers as far as modeling appropriate behaviors, prepare her for society? The third factor they looked at was kind of her behavior. Did the effect of Rachel's presence, impede the teacher from teaching the way she would have, or other students from learning? And finally, the cost to the district. So was the cost excessive or not? The court's findings were that, one, the Shalom teacher's testimony proved Rachel had satisfactorily benefited academically from regular class setting, right? And that's as opposed to the state test. So the Shalom teacher argued that, yeah, I have evidence from what has happened in school that she is making academic progress and it is satisfactory, whereas the district called in the state testing agency and they basically pointed to the facts that they were familiar with, that she had not met what was proficient on those state tests or made the progress they expected a normal student to make. The second factor, they found that Rachel was motivated and learned socially through imitation and modeling in the regular classroom. On the third factor, they found that Rachel was not disruptive to the teacher or students. She did not create a burden on the teacher as far as planning time or preparation, which would have taken away from other students. And the school must prove that Rachel's presence would significantly impair other students' abilities to learn in order for them to exclude her. And the fourth factor, the cost, the district had overstated the cost according to the court of regular placement, and you can only exclude a student when the cost is excessive. So again, they estimated $109,000, and the courts looked at it and said they'd included $80,000 for sensitivity training, which they weren't sure if it was appropriate, and the state would have provided that for free. And the courts found that there would be zero to little additional cost for putting her in the general education classroom as opposed to pulling her out into a special education room. The court's decision was ultimately that the district failed to demonstrate its plan to include Rachel less than half the day, provided mainstreaming to the maximum extent appropriate for the individual in question. So the key there is the individual in question. You know, it goes on a case-by-case basis. So the court made that very clear that Rachel is a unique person, and what was appropriate for her was not met in this situation. And the hearing officer's decision was ultimately upheld. So the court confirmed what the hearing officer had stated earlier. My personal response, I agree. I think Rachel has the right to be placed in the least restrictive environment. Comes right from IDEA. And if you look at the four factors that were taken into consideration by the court, they seem to be common sense. You know, those are things you'd have to consider before including a student. And all four of them supported her argument. So the teacher and parents' testimony demonstrated academic, social, and behavioral impact favored Holland. And finally, on that cost one, which is what the district really got hung up on, the cost was dramatically overestimated by the district, and FAPE requires appropriate education at public expense, under public supervision and direction, without charge. So they basically made the argument that the district failed to fulfill their burden of showing that the cost would be excessive. Implications for educators: all students are entitled to a free and appropriate education, right, under IDEA. Students must be included in the regular classroom to the maximum extent appropriate, right? So keywords: maximum extent appropriate, and what's appropriate varies in each situation. And finally, the schools receiving federal funds must abide by the IDEA, IDEIA regulations. So if your state accepts those funds from the federal government, then they have to abide by the federal law. Tips for teams. So if you find yourself on a special education team as an educational leader, here are four things you really want to keep in mind, and those are the four factors that the court used to help determine appropriate placement. So one would be the educational benefit. Is the student you're evaluating going to get a satisfactory education in the general education setting? It does. Pardon the interruption. The educational benefits don't have to be, greater or extraordinary in the general education classroom. They just have to be satisfactory. And then you look at non-academic benefits. Is the student getting other things other than just, academic material from the setting? So are they learning from being with peers, their social behaviors, what's appropriate and what's not, as that is also an important part of the school process. Third thing was, again, the effect on the teacher and other children. So if you put a student in a placement, is that going to have a negative effect on the other children, or is it going to burden the teacher to an extent that they're unable to provide a satisfactory education to the other children? And finally, the big one was cost. And cost, you have to be careful that you appropriately state the cost and you don't overestimate it, as we saw in the Holland case. Another important point here, a 12-year study over due process hearings found that 50% of those due process hearings involved placement challenges. So this is, I believe, from 2003. About half of all special education hearings deal with placement challenges. So when you're working through the IEP process, we really want to make sure that we're getting the placement, making it appropriate. And I think also communicating with parents to make sure that they are comfortable and they understand the law, so that they don't feel like they were left out of the process, or maybe their concerns weren't heard, or that they don't understand the law, to ensure that litigation doesn't come against the school. And 3 questions for the class. First one, what information would you use as a member of an IEP team to determine the appropriate setting for a special education student? Second question, what breakdowns in the IEP creation process do you think are responsible for the high proportion of placement cases? Finally, have you ever experienced a challenge from a parent over a student's placement? Or have you ever had a concern yourself about a student's placement?